Good morning, and welcome to this first workshop session on legislative updates. My name is Daniel Kilpinen. I work with the Orange County Neighborhood Preservation and Revitalization Office, and thank you for being here. In this workshop, you will find out the latest laws that have been passed by the county and the state, and how these changes may affect your homeowners association. Our speaker is Frank Ruggieri. He is the founding member of the Ruggieri law firm, PA. He has devoted his practice to the Central Florida area since 1996, when Mr. Ruggieri first began practicing law. Beginning in 1999, he has focused his practice on representing community associations exclusively, including condominium, homeowners, and mobile home communities, in addition to related community development districts. Mr. Ruggieri has prosecuted and defended covenant violation, collection, commercial, and construction defect cases on behalf of the firm's community association clients. He has been published in various community association periodicals, submitting articles regarding collection and covenant violation litigation. He has likewise spoken on community association topics at Community Association Institute and Orange County Homeowners Forums, in addition to teaching courses certified by the state of Florida for continuing education credits for licensed community association managers and state-approved board member certification courses. Please welcome Mr. Frank Ruggieri.
Thank you. Good morning, folks. How's everybody doing today? All right. As my very kind cohort here hinted to, today's course is about new legislation in Florida. Okay. As we started to talk a little bit before we got started, we've had a couple of busy sessions here in Florida last summer and again this spring, and the new statutes generally take effect on July 1st of each summer. And so we essentially have 2 years of new legislation that we need to cover today. We've got 1 hour to do it. So what I'm going to do is just kind of ask you guys to hold your questions until the end, and then I'll be happy to take them, and I'll certainly be willing to stay after and answer any questions that you guys might have. Okay, so let's jump right in. What we're going to cover today, real quick, new legislation generally affecting homeowners associations, condominiums, timeshares, and cooperatives. What you're going to see throughout the course is you will see citations to the various statutes, 718, period 111, things like that. Okay, those are references to the statute. Use those. You can Google the statute online. You will see references to the various bills that were considered by our state legislature. So, for example, if you see HB 617, that means House Bill 617. You can very easily Google that, go online, do an internet search for that, and you'll locate that very easily. Because I do have to kind of move quickly today, certainly we've got the materials. Make sure you get a copy of those materials, take them with you. If you've got questions, research those statutes a little more online, or you can certainly send us an email, and I'll be happy to answer it as best I can. I certainly can't answer questions specific to your community without getting a little bit more involved and looking at your documents and whatnot, but if you've got a general question about the statute, I'd be happy to help as best I can. So let's go ahead and jump right in. Starting with estoppel certificates. This is a big one, okay? This is Senate Bill 398. We had new statutes that were adopted nearly identical with respect to homeowners associations, condominiums, and timeshares. Or cooperatives rather, identical as to all three. So the changes that I'm going to cover, what you'll see is the language of that statute is identical as to all three of those forms of ownership. Real quick, estoppel certificate, what is it? Generally, any bank, any closing company, title company is going to request a statement from the association saying what is owned on this unit or what is owed on the unit. Give me a statement of account. There are various requirements that come along with that, okay? Estoppel certificates are very important because you've got an individual that is closing on property, they're purchasing property, and you're giving them a statement of account of exactly what the status of that account is. So we've got new requirements that are now imposed. So keep in mind a few major things with this. Okay, we've got a set fee schedule. Maybe that's the most important part of the new estoppel certificate statute. You can only charge certain set amounts based on the status of the account. We've got an initial fee of $250. That is a cap on what the association can charge for the preparation of that estoppel certificate. You can charge an additional fee if it is the account is delinquent or that it's being requested on a rush basis. A couple of other important points: make sure you've got a policy in place on how that estoppel certificate is prepared, who prepares it, and what that fee schedule is going to look like. Generally, those are prepared by legal counsel, sometimes the management company. The association could even prepare it itself if need be, but just make sure that you've got a policy on that and that it complies with the statute. Okay, so we've got some new requirements now applicable to condominiums with respect to official records and maintaining them on your website. We've got a deadline. This deadline was changed this past summer. It's now July 1 of 2019. Okay, essentially, if you've got a condominium with 150 or more units, you're going to have to post certain parts of your official records, have them available on your website. Folks, we're getting to a point now in the digital age where more and more, whether it's an official records inspection, whether it's an election, whether it's voting, things like that, we're going to move into that digital age where it's going to be taking place digitally. These guys are really, they're just going to keep throwing the barriers at me here. All right, financial reporting. We've got some new requirements with respect to financial reporting now. We've got to comply with new deadlines in the statute, 5 days to get that financial report to the unit owner. Failure to comply with this financial reporting requirement and give that report can now result in some significant penalties. We've got some, the DBPR can essentially impose penalties against the association for not complying with those financial reporting requirements. So be mindful of that. That's 718.111 subsection 13. And as you can see here, we're talking about unit owners in a condominium and in a homeowners association as well will now be able to alert the DBPR if we don't provide that financial report in a timely fashion and result in some penalties to us, okay? Debit cards. This is an interesting one. Essentially, the association cannot use debit cards to make common expenditures. This was a new prohibition that was put into the statute. I suspect it has to do with simply the ability to recover from a situation if we've got a board member that may do something less than honest with that debit card, right? We've got term limits now for condominiums, 8 years. Here's the key to this one, okay? This is the one thing that I want you guys to remember more than anything when we're talking about term limits, okay? With an 8-year, it's essentially an 8-year term limit for condominiums. The key to me as an attorney when I look at this, all right, is that 8 years going to run if you've already been seated on the board for, let's say, 4 years, and now we've got this new statute that's taken effect that says you can only serve 8. Can you only serve 4 more years now that that statute's passed, or does the 8 years start to run from now when the statute has passed? My personal take on it, it's a brand new statute. You've got a right to serve on your board or at least run for the board as a member of the association. So my take on it, that 8 years runs from right now. Recall. We've got some changes to recalls in condominiums that we need to be mindful of. I'm not a big fan of these changes, okay? Essentially, what has happened with these new changes on the recall provisions or the recall procedures to recall a board member is we've kind of sped up the process. The way that they've modified the statute, it allows that recall to take effect much quicker. The board has less leeway to have a meeting and review the voting documents and the things that the unit owners use to conduct the recall and make sure that things were done proper. I've seen recalls done completely improper by homeowners or condominium unit owners, and that's why I kind of favored the old version of the statute, because there was a process there for the board to kind of look at things and say, hey, you know, this signature looks strange here, I'm not sure what's going on here, and kind of look at the process and make sure that the voting was done properly. That's kind of gone away. So a recall is going to take effect a little quicker than it used to. So be mindful of that. Division arbitrators, now on arbitrations, they've got to issue their ruling within 30 days of the hearing. So that kind of hastens the process for arbitration. So if you're in a condominium covenant violation type dispute, or an election dispute, there are going to be a mandatory time frame now for the arbitrator to issue that ruling. This is an extension, what you're seeing here, folks. Just be mindful of this. Like I said, I've got limited time, so go back if you've got concerns regarding potential conflicts of interest in a condominium and you're on the board, whether it be your ownership or partial ownership of a company or a transaction with the community that could potentially be a conflict of interest. Make sure that you're mindful. Go through, take a look at these statutes, and if you need to get consult with an attorney, please do so as a board member before you do that. Suspension of voting rights in a condominium for a delinquency. Be careful. This is a fairly common remedy that I see in condominiums, suspension of voting rights for a delinquency. That delinquency must now reach $1,000 before voting rights can be suspended in a condominium. Okay, so be mindful of that. Condominiums, you must provide a listing of all of your bank accounts to the DBPR. They're going to start maintaining a register of that information on condominiums in the state of Florida. This information can be obtained from unit owners in a condominium directly from the state, from the DBPR. So they're going to maintain that registry, that directory, if you will. Okay, House Bill 6027. I mentioned this a little bit before, the financial reporting requirements. Understand that this particular bill added those requirements to 718 and 720. So these apply to both homeowners associations and condominiums. Essentially, the rules that were there that kind of relaxed financial reporting for smaller communities of fewer than 50 units, those have been taken away. The bottom line, the thing that I want you to take away from this, financial reporting is going to be dictated by your revenues. What's your annual budget? That's going to dictate what form of financial reporting you have to engage in, whether it's a simple report of cash receipts and expenditures, compiled financial statement, or a fully audited financial statement. Okay, that exemption based on 50 parcels for that financial reporting, like I said, that also was added to Chapter 720. So for those of you that are in smaller communities, smaller residential subdivisions, a homeowners association, be mindful of this. You may have been doing a relaxed level of reporting because of the number of units in your subdivision, in your community. That's now gone away. It's determined solely based on your level of revenue, or not revenue per se, but what your annual budget is. Okay, so be mindful of that. Condominium terminations, there's a process, folks. Just be aware of this. If you reside in a condominium, there's a procedure to terminate the condominium. As Dan pointed out at the beginning of the presentation, I've been representing community associations. That's been the focus of my practice for 20 years. I have yet to see a condominium successfully terminate. So, not very common. Okay, House Bills 841 and 617. I'm going to slow down a little bit now, okay? What we're talking about at this point are going to be the changes that just took effect about 2 weeks ago, okay? And then there's also an additional change affecting homeowners associations, essentially, that will not take effect until October 1st. It's a very important change to the statute, so I'm going to slow down a bit now, cover these in a little bit more detail. Condominiums. Be very mindful of this change, folks, okay? What they did with respect to condominiums, there are certain portions of your official records that now must be maintained from the inception of the association, okay? From the time that the association was first incorporated. Now, and that includes really the documents that you might expect, okay? The board meeting minutes, okay, the governing documents for the community, and some other things that are outlined in the statute that you must keep from the inception of the association. So be mindful of that. The natural question is, well, Frank, what do we do if we don't have those records? Well, a court of law you cannot be punished for not having something that you simply don't have, okay? The only thing that we can do is admonish you to start maintaining those records going forward. So obviously this is a new statute. Condominiums aren't necessarily prepared if they've been around since 1990 or 1991. They may not have those things, right? The prior version of the statute said 7 years. So very likely that you would not have those records. So maybe most importantly, understand that I don't believe that there can be a penalty for that. You simply don't have those records. They weren't maintained. They weren't required to be maintained for that long. So, deadline to post digital copies of certain official records in a condominium, be mindful of this, was changed to July 1, 2019. So you've got until next summer to get those records on your website if you've got more than 150 units in your condominium. So you've got till next summer to get that requirement satisfied. Again, this is a matter of time, folks. I would guess within 5 years, official records are going to be mandatorily maintained on a website, or at least you must have that available to your unit owners. And certainly when that change eventually takes place, you're still going to have to maintain hard copies of everything, because not everybody has internet access. It may not. We can't assume that everybody has access to the internet, so you're going to have to maintain hard copies as well, and that still applies now, obviously. But eventually, I believe the legislature is going to require that you at least have the vast majority of your official records accessible on a website, accessible in digital format. And that same is going to apply for voting, I believe, eventually as well. We've got certain requirements on posting contracts on the website. Those are detailed a little bit more in the statute, as you'll see. Be careful in a condominium. They added some new requirements where you are going to consider a special assessment. The notice requirements for that meeting. They've added basically that notice must be a little bit more detailed, okay? You've got to specifically state that assessments will be considered and provide the estimated cost and description of the purposes for that assessment. So the notice requirements for those assessment meetings in a condominium are now more stringent. This is something I absolutely anticipate eventually making it into the Homeowners Association Statute, Chapter 720. And really, I think it's advisable. I think it's just good business practice as a community association when you're going to have a meeting to consider the adoption of an assessment. I think it's a good idea to provide some detail in there. It does not need to be a half page or even a paragraph, but provide some basic information to your unit owners. Let them know what what the purpose of that assessment is, and certainly the amount and whatnot. Again, we've got the statute now authorizes notice of board meetings under 718.112, again for condominiums, to be posted on the association's website through adoption of a rule. This is what I'm calling kind of the foot in the door to electronic notice of board and membership meetings in community associations. Right now, this is exclusively for condominiums, okay, 718, subsection 112. However, just like we were talking about with the official records on the website, and just like I mentioned with electronic voting, we're going towards that digital age. And this is another example of that. Eventually, we're not going to have to provide paper notice of meetings anymore, I don't believe. Not sure how long that's going to take. It could be 5 years from now, 10 years from now, but this is the first step towards that. And I think it's a good step, right? I mean, this is... we're relying more and more on digital notices or digital access to things. I'm seeing a couple faces in the audience here that maybe we're not 100% happy about that, but I think it's a good thing. I think it's a good thing. So many of my clients ask for this. Frank, can we just put the notice on the website? No, you can't. Statute requires. Must be posted conspicuously or mailed. Okay? So... currently, you certainly cannot post the notice on your website in lieu of the physical posting. That's not okay. Right now, we still have to physically post or mail that notice out, but we can now adopt a rule in a condominium and provide that notice on the website. And at least save. So that's really what this is all about, folks. The number of phone calls that I've gotten over the years from licensed community association managers and board members complaining about mailing out notices for things, because that can cost a lot. I mean, I represent a community that's composed of 3,600 homes. Every time they send out a notice of a meeting, it costs them approximately $10,000. That's how much they spend on noticing to get all between the copies and all of the mailing when you've got to send out a packet of information. Their annual meeting notice, all of the voting documents that go out with it, all of the man hours, the copy charges, the mailing and postage, all of that, a community of that size, it's a very significant expense for them. And that's all relative too. Their budget is very large because they have 3,600 homes. Well, what if you're in a 100-home residential subdivision and you're having multiple meetings because you're having a lot of issues? That can get expensive. Okay, we talked about this a little bit before, 718.112 and the changes to the recall provisions of 718 condominiums, okay? Be mindful of that. Like I said, I'm not a big fan of these changes because it kind of shortens the process and makes it go a little bit faster, and I'm not sure that that's such a good thing when we're talking about removing board members by a homeowner vote. Those things aren't always done properly. Another issue that I tend to see with these things too is maybe some misinformation being distributed in the community and making suggestions about board members maybe doing some things that are very bad that they're not really doing. I like the process to go a little bit slower, I guess, when we're talking about removing board members. Number one issue that I see, folks, in community associations, having done this for 20 years now, is apathy. You might think of, well, it's construction defect issues or delinquencies, right? No, it's apathy. It's lack of participation. I was talking with a gentleman outside. I represent a client where it's been effectively administered by the same two board members for 19 years. I've represented this community for 19 years, and there's people laughing because they're in the same situation in their communities. This young lady here, she's got a smile on her face, raising her hand in absolute exasperation because no one else will serve on the board in her community. Right? So that's why I say that's the number one issue that I see is apathy, is a lack of participation. And I always encourage homeowners when I go to my meetings, I encourage the homeowners that are present to get involved, get on your board, go to a board member certification class, which I teach. Several other attorneys in Central Florida teach them as well. Get educated, get on your board, and help out. And by the way, I'm not a member of my board of directors, so it's a little different from me. I'm a community association lawyer, so that's a little problematic for me to serve on my board. I'll end up getting 19 phone calls a day, and it'll become a full-time job. Condominiums, material alterations, okay? Understand that if you're going to make a substantial change to the use, function, or appearance of your common elements in a condominium, that is always going to be subject to a unit owner vote unless you have some very specific language in your documents that allows your board to do it without a unit owner vote, which is rare, okay? Some changes to the statute now that I'm not a big fan of that basically talks about the need to have the approval for a material alteration happen before the alteration can commence. Well, yeah, that would seem to make sense, but here's the problem with that. Having represented communities like I have for 20 years now, okay, everyday folks that serve on their board aren't always aware or cognizant of a material alteration vote. And maybe they do it and then they go, oh, wait, they find out maybe from an attorney at the Orange County Community Conference or something like that, oh, man, we had to get a vote. So let's go back and fix it. Let's get the vote. And it could be something that the entire community was behind. It was needed. It was necessary. And now you're faced with this issue. Well, what does that mean? If you didn't get the approval before and then you make the change and now you're trying to get the approval and your community's behind it, well, now what does that mean? When the statute says that it had to be approved beforehand, does that mean that you have to tear that improvement out and then go get the vote and then do the improvement again? I don't know. The courts of our state are going to have to work this one out, and it's going to be a difficult one. Change to the fining statutes. Now, this took place I'll talk about this for homeowners associations as well. Not all that significant of changes. I think they add a little bit of confusion to fining, I believe, the changes that they did make. So a fine or suspension that's approved by the committee in your community that is set up to approve fines, payable within 5 days after the date of the committee meeting at which the fine is approved. Well, here's the problem with that. If the fine is going to be due 5 days after the committee meeting, and like I said, keep in mind this applies to homeowners associations as well. I'll point to the 720 section in a second. What happens if the fine that we're talking about is for a continuing violation? How can the fine be due 5 days after the committee approves it when the violation is continuing? Because if the violation is continuing, the fine can continue to accrue. How do you pay a fine when you don't know what the amount is? Continuing violation, the classic example is parking. Okay? You've got a commercial vehicle restriction in your community. Can't park commercial vehicles. Homeowner is bringing in a large delivery van and is parking it there every night. Parking of the commercial vehicle. And the board votes to impose a fine, committee approves it. It is supposed to and can accumulate under the statute on a continuing basis for each day that the violation continues up to a maximum of $1,000. Unless your documents in the case of a homeowners association allow you to fine more than $1,000. Okay? So if that is a continuing violation, the board votes to impose that fine against this individual with the delivery van. The committee approves it, and it's supposed to start accumulating at $50 a day. Statute says it's due 5 days after the committee approves it, but it's $50 a day and it's continuing, and it doesn't take effect until after they approve it. So how can the individual pay it within 5 days of the committee meeting? I don't know. What do I think? It's due 5 days after the date it becomes final. It's the only way that you can do that if it's a continuing violation. You've got to reconcile the statute in a way that makes sense. That's what we have to do as citizens and as judges, as lawyers. That's what we have to do. We have to reconcile a statute when it's a little bit confusing like this and try to make it make sense when we can. So that, to me, is how you would make that make sense. If it's a continuing violation, statute says 5 days after it's approved, well, 5 days after it becomes final, which is 5 days after the date that it reaches its maximum. I'm going to take this opportunity to introduce a very important new change to the statute. What you're going to see here, folks, this is 719 for cooperatives, okay? But what I want to point out, second line there, members of the board may use email for communication but may not cast votes by email. Okay? Number one, this is already in 718 and has been for, I think, 2 or 3 years, maybe longer than that. It's now in the cooperative statute, and it's also, as you're going to see in a second, in 720 for homeowners associations. Now, here's the thing. All board meetings must be open, right? Anytime a quorum of the board gathers to conduct association business, you have a meeting. Well, as an attorney, I would argue if the board is communicating by email, more than a majority of the board, that in and of itself would qualify as a meeting because you're conducting business and there's more of a quorum of you, at least a quorum of you. In other words, voting by email, in my opinion, has always been prohibited. Now, Chapter 617, Florida's Not-for-Profit Corporation Act, as well as just about every set of bylaws I've seen for a community association, allows you to act by, in writing, unanimous written consent in lieu of a meeting. This doesn't change that, in my opinion. If you can enter into a written consent, not an email, but a written consent that is signed by every board member, then you can act in lieu of a meeting and you would ratify that vote at your next regularly scheduled meeting. This, in my opinion, does not change that. this prohibits voting by email. If a written document is circulated amongst the board and every single board member signs that document, I believe you are in compliance with the statute. Circulating emails? No. Circulating a written document that each board member signs is still okay. Okay? But voting by email, cannot do it. But again, in my opinion as a community association lawyer, I believe it was prohibited before the statute was adopted, because you're acting outside of a meeting when you do that. Okay, 72303, homeowners associations. Members of the board may use email for communication. Again, just like we were just talking about, can't cast votes by email. So this is now in Chapter 720 for homeowners associations, 720.303. Notice by electronic transmission has been expanded to any member who consents in writing and has provided a fax number. Okay, so that electronic notice in a homeowners association, it's been expanded a bit. And actually, I think this is kind of just a legislative approval of things that we've been doing for years. I think homeowners have been getting notice by fax in certain situations probably for years now. It's now officially approved and sanctioned, if that person has consented, again, to receive notice electronically in lieu of written notice. We were talking about the changes to the fining statute. These changes have also been made to Chapter 720. Okay, same thing. Due 5 days after the committee meeting. That's the big change to the fining provision. We talked about that already. If it's a continuing violation, I believe that 5 days will start to run after the fine has become final. Amendments. The format requirement for amendments. For as long as I've been doing this, 718, the Condominium Act, has required that amendments be proposed and adopted or presented to your membership in a particular format. What is referred to as the deletion and strikeout format. You folks are, I'm sure, are familiar with it. Okay, our state legislature does that. If you look at a new statute, so for example, we talked about finding these bills online. If you go online after the class today and you go and you look up House Bill 617 in Florida, you'll pull up a PDF. You can find that through the legislature's website. You'll open that PDF and you'll see deletion and strikeout format. Striking through removed language and underlining new language. That's now mandatory for homeowners associations as well. If you're going to propose an amendment, it's now got to be in that format. And that includes what are referred to as Scrivener's error amendments, where you're just correcting a misspelling or something like that. Okay? Elections. I'm telling you, I think the legislature has been watching my files. They've been watching my cases. Okay? Because this new statute came in on elections that it seems to be based on a case that I have got going on right now. Okay? An election dispute. Unfortunate election dispute that's been going on for nearly 3 years now. If an election is not required because there are either an equal number or fewer qualified candidates than vacancies exist, and if nominations from the floor are not permitted, then qualified candidates commence service immediately, even if a quorum is not present. Be mindful of this. This, to me, I think, was in part done by the legislature to address these communities, the apathy. I read your lips. She's right. Okay, the lack of participation. I mentioned the 2 board members in my community that have been on the board for 19 years. Okay? What this provision says is, let's say your bylaws allow for voting in advance of the meeting and there are no nominations from the floor. Okay? We have to start with that basic assumption. You don't have nominations from the floor in your election, okay, in your HOA. Second, there are There's not more candidates than vacancies. So let's just say you've got 2 vacancies and you only have 2 candidates. No election would be required, right? Okay. Third, you do not reach quorum. So you don't have enough homeowners present to convene the meeting. If all of those things are present, in the old days, the new board or the old board would just stay on because you didn't reach quorum and no need for the election. So because we didn't have a meeting, those 2 people that tried to volunteer did not make it onto the board. And I'm seeing all kinds of smiles in the audience, right? You guys have, I think many of you have probably seen this happen in your communities. Now, those 2 individuals that raised their hands at the meeting that couldn't be convened because you couldn't make quorum, those 2 people are now on the board. Okay? So a little help with the apathy from the legislature. This is a good change, 723-085. How many times has maybe a delinquent individual, homeowner in your community, sent in a check for a partial payment and then wrote on the bottom of it, payment paid in full? Payment in full, even though they didn't pay the entire delinquency. How many times have we seen that? Now, under the new version of the statute, even if you were to accept that payment, and it says payment in full, that's not going to prejudice the community in any way. You're not going to waive your rights to recover the full delinquency. The bottom line is you accept that payment, you apply it to the homeowner's account properly in accordance with the statute, right? Interest, then late fees, then attorney's fees, cost of collection, then the assessment. That's how you properly apply a partial payment, okay? So now you get that payment with the restrictive endorsement that says paid in full. You deposit it without concerns. You're not going to waive anything or lose any rights. All right, House Bill 617. This is 2018, right? It's 2018? Okay, so if we subtract 30 years from 2018, that brings us back to 1988. Okay? How many of you live in a community, in a homeowners association, where your documents or the community was developed before 1988? 1, 2, 3, 4, 5, 6, 7. Okay? Florida's Marketable Record Title Act, I call it the Public Record Cleaning Act. Basically what it does is it says certain rights that are created in a piece of real estate will go away if you do not take action to preserve them with a public record notice within 30 years of the date that they were recorded originally. Okay? That applies to restrictive covenants, which is your governing documents, your declaration of covenants, conditions, and restrictions. Okay? That is a restrictive covenant, and it is subject to the Marketable Record Title Act. So if you do not take proper action under Florida's Marketable Record Title Act, which is Chapter 712, okay? If you do not take action under that statute within that 30-year time frame, your covenants will expire. Okay? The document that you prepare and record in the public records within that 30-year time frame is a simple, fairly simple document. Well, I take that back, not a simple document. You absolutely need the assistance of legal counsel to properly do a preservation notice. But that document can be approved by the board of directors. Guess what happens after the covenants expire? Now you have to go through a very lengthy and expensive process to revive your covenants. It requires a homeowner vote. Okay? It also requires that you send copies of all of the documents out to every homeowner that lives in your community. So not only are you going to need a homeowner vote, which simply due to lack of participation sometimes is very difficult to get, but now you're also going to have that significant expense that you're going to have to incur to undertake the process and get the proper notice out and get copies to everybody and do everything that you've got to do to properly revive your documents. Okay? I've not been a fan of this statute, and it's because I'm a community association lawyer, okay? There's kind of this little battle between guys like me and gals like me and the attorneys that do title work and do title transactions. They think that covenants should be wiped out after 30 years, and you know, I'm a good guy. I'm on the good side. I think covenants should never get wiped out, and they should always be preserved. They're the cornerstone of our communities in the state of Florida. They maintain property values. They give people visibility on the scheme of development and the restrictions that exist for the community. It also creates mandatory assessments. Guess what? The county's not coming in to maintain your common areas unless you have a MSBU like this young lady in the back. Okay? All of us have improvements in our community that the county's not coming in to maintain. If those assessments aren't there, how are those areas going to be maintained? And rest assured, if they fall apart, they're going to negatively impact your property values. Okay? So those covenants play a vital role in the community. So that's why I'm not a big fan of the Marketable Record Title Act and wiping out covenants. So, very happy to see the change that they've made to the statute. Effectively, what it says is there are certain other things that you can do other than a preservation notice, namely amending your documents that will act just like a preservation notice. And I'm a fan of that because it kind of kills two birds with one stone, right? So let's just say that you're in a community, and the community, this is 2018, right? Community was developed in 1989. So we're coming up against that 30-year deadline where your covenants are going to expire. And let's say that the community is also interested in adopting maybe some new leasing restrictions, okay? Maybe we want to avoid the Airbnb rentals or something like that, and the community wants to adopt a new leasing restriction. Well, what you could do, consult with legal counsel, have your documents looked at, but you should now, under the new version of the statute, be able to adopt that amendment. It must be in a particular format, have certain information in it, and that amendment will effectively kill two birds with one stone. You modified your documents, you amended it and added that leasing restriction, and you also took action to preserve your covenants. Okay? Also, under the Marketable Record Title Act, this young lady in the back, and I'm actually very glad that you raised your hand and you told me about your MSBU and how you're angry at title companies because they keep calling you for estoppel certificates, because this is kind of the next change to the statute that I want to talk about affects you directly. Okay? Your covenants will expire as well. If you have restrictive covenants in your community, just because you're not subject to 720 doesn't mean that your covenants won't expire.
I followed that.
Okay? So, the statute now contains a process for communities like yours to make certain that your covenants don't expire. So there is a process now in the statute for communities that are not subject to 720, where you don't have mandatory membership and you don't have lien rights, or maybe you don't have both, right? So the statute now has this process in place to make things simpler on you folks, to make sure that your covenants don't expire. So, all right, 5 minutes left. We've got questions. Dan, I don't want to violate your rules. You mentioned questioners having the microphone when they ask questions. So please, folks, may you open it up to any questions? This gentleman over here, please, sir, grab the microphone.
Yes, I'd like to talk about estoppel certificates.
Yes.
We'll get an estoppel request from a title company, and then we'll get one from a bank, okay? The bank has come back and said, we're not asking for an estoppel, we're asking for a questionnaire. So, and they're asking for a lot more than we have on our estoppel certificate. How do we stop this? Because the bank has told the prospective buyer that they will not close unless they get the information they're requiring.
Right. Okay. Excellent question, sir. So his question pertains to what I call the gratuitous the gratuitous banking questionnaire that many communities receive from certain financial institutions because they've got certain lending requirements that they need to comply with. So they will ask for information that the statute simply doesn't require that we provide. And that's kind of the answer to your question. Okay? The estoppel certificate is a process in place that allows someone, a bank namely, that's financing a purchase in your community to get information about the delinquency involving that property, whether there's violations, okay, the insurance company for the community, and the other categories of information for estoppel certificates that are specifically identified in the statute. The statute does not say anything about the percentage of residences in your community that are being rented and that you have to disclose that to a bank. But many of them want to know that. Many financial institutions want to know how many units, how many homes in your community are owner-occupied versus renter-occupied. That is a category of information that is not required to be disclosed, excuse me, under the estoppel certificate statute. Okay? So my suggestion to you is if you're being bombarded with these requests, speak with your legal counsel, have your documents looked at, but you could certainly adopt a policy on this. If a bank wants that additional information, you could adopt a policy and you can charge for that. So you could comply, that's one way to do it, and charge for it because there's going to be time and expense involved in gathering that information for that particular residence and providing that to the bank, okay? The other option is you simply say we're not going to provide it because we're not required to. Now, another part of your question was, well, Frank, the bank said that they're not going to finance the transaction if we don't provide this information. That's another aspect to this, okay? So whenever my clients ask me about these gratuitous banking questionnaires, what I tell them is this, okay? Properties can't sell in your community without banks. They are financing the acquisition of properties in your community. People aren't walking around with 6 figures of cash in their bank account to go out and buy a house. They do it, just like me and just like all of us, you finance the purchase. Okay? So what does that, Frank, what are you getting at? What I'm getting at is that to a certain extent, you want to encourage financing in your community. You want to encourage, make it easier perhaps to get financing in your community and maybe cooperate with those requests because what you're doing is certain financial institutions are the ones that are requiring that, and many times it has to do with FHA financing. Okay? So in order to assist with sales in the community and help sales, maybe you adopt a policy that provides it. So sometimes, I tell my boards, look, it's helpful to your homeowners to provide this information because it's going to facilitate sales. It's going to help with financing. So maybe you want to do it. Maybe you want to encourage that. So it kind of depends on how you want to look at it and how your board feels about your particular community, what your homeowners want. Any other questions? Yes, sir.
In our community, we originally had 5 sections of covenants and restrictions, one for each section as it was built. So 3 or 4 years ago, we went through a whole process to create a single covenant and restriction for all 6 sections. Does that then reset the time for the 30 years to when those were consolidated?
Okay. Excellent question. So, gentleman's question is essentially whether what his community did in combining these documents, combining the separate covenants for the 6 sections, does that satisfy the change to the statute on the Marketable Record Title Act, House Bill 617? Okay. Number one, that's difficult question for me to answer. I would really need to see exactly what you folks did. But let me say this. Based on my knowledge of restrictive covenants and what you would have to do to take 6 separate documents like that and combine them into one, most likely what you folks did would satisfy the statute. Now, here's the caveat to that. What attorneys are now trying to figure out with this new statute on the Marketable Record Title Act is whether it will apply to an amendment that was done before the statute took effect. Because the statute does not take effect until October 1st of this year, another 3-4 months, okay? So that's the question that attorneys are now debating here in the state of Florida, is whether or not an amendment done before October 1st of 2018 can satisfy that new statute. My personal take on it, to a certain extent, I think it's going to depend on on your particular documents. But the way the statute is written, I think you've got a good argument that it does. But that's definitely one where you want to have an attorney very carefully take a look at that and provide you with a formal opinion. And there's always the easy way to resolve this, okay? Because like I said, that preservation notice under the statute can be adopted by board vote. You don't need a homeowner vote. So to a certain extent, maybe the best advice that an attorney could give your community is just to go ahead and do it and be safe, because it's a board vote.
All right, so that concludes this first workshop of this morning. Let's give thanks to Frank for that informative information.